The Obama administration came into office with a campaign statement that the Obama administration looked favorably upon the ICC as a part of its overall commitment to the use of multilateral institutions and activities in its foreign policy, but that there would have to be a formal policy about the ICC which would have to have the full participation in development and the full agreement and results of the Department of Defense, a rather characteristic combination of Obama broad vision and caution at the same time. When we first began to interact shortly after they were confirmed with Legal Advisor Coe and Ambassador Rapp, we found a combination of things. We found a very strong commitment to the ICC as a matter of principle, and a much better understanding of what it did, how it works, and what it was about than was the case in the previous administration, and also a certain anxiety and caution, which was, I think, understandable. They had an action-forcing event for them, which was the review conference. They had to decide what to do about that. A decision about going to the review conference clearly involved a decision about whether, after an 8-year absence, the United States would start going again to the court's governing body, the Assembly of State Parties, which is to the ICC what the General Assembly is to the UN. We were impressed by the care with which they approached those decisions. We were also impressed by their sense of realism. Like all incoming people, they started with a certain number of presuppositions. They were quite prepared to test those presuppositions against investigation, action, and consultation. And some of those presuppositions were abandoned in the course of making the decision to go to the Assembly of State Parties, and in particular in crafting the diplomacy that they used there. Okay, so much for background. You've heard about at length what happened in Kampala. I would remind you that the Kampala conference, the last week was about aggression, but there was a first week in Kampala which was committed to an activity called stock-taking, which was essentially an assessment through a series of panels, groups, discussions, and so forth, of the current state of international criminal justice at large, and in particular of the ICC and its role in that system of international justice, a system which, because of the ICC's preeminent place, is now beginning to be called the Rome system of international criminal justice, or international atrocity law, as a term that David Sheffer and others have begun to introduce, and which I find it useful to use, since for a lot of people referring to war crimes and things like that as international humanitarian law has a certain contradictory flavor. A major consequence of Kampala from our point of view, this may well not be a major consequence from the government's point of view, but it is for us. We had intimations before Kampala that the U.S. would no longer try to create a formal policy on the ICC. And this stance has been confirmed to us repeatedly by various officials of the U.S. government afterwards. What we are told is that it's no longer necessary to go through a policy review process, even though such a process had begun earlier in the administration. No longer necessary to do that because the various speeches, statements, positions taken by the U.S. about the ICC cumulatively constitute a policy. Now, there are very serious problems with that. I just want to tick off a few. I want to say that in many ways the Obama administration has been so good about the court that it may seem churlish to object and to contravene in this way, but there are, and I'm just going to tick these off, a series of, for us, quite important consequences that flow from this. Obviously, in the United States, we look forward over time, and this is time in years, eventually to a ratification by the United States of the Rome Statute. Everybody knows how difficult it is to get a ratification. Everyone has heard the horror stories about never being able to get treaties through the Senate for its advice and consent. The law of the sea is the leading horror story. Everyone knows that you only get really one chance at getting advice and consent from the Senate, and if you don't make it, it goes to the end of a very long line. Achieving ratification, however, means a start now. And a start now means consciously developing a relationship with the court which will produce a relationship, a sense of familiarity and comfort by the Congress and the executive branch with the ICC that in due course can make it politically practical to try for ratification. This is a long-term perspective. Many administrations normally don't pay an awful lot of attention to issues that are as long-range as this because the people in charge now may well not be there in the future and they have to cope with urgent, immediate problems. But for those of us who are committed to the ICC, this is something we have to start working toward now. We believe that you can't get a relationship with the court which will do what I've just said unless you have a policy matrix for it, a formal policy matrix for it. If you don't, you will have a situation where you do not have established machinery in the government to deal with problems that may come up at the court. And everyone, all of the people in this room who've had experience with international organizations know that sooner or later something or some things are going to happen at the court that will deeply offend the United States and may feel that the court is going in a direction which is contrary to American national interests. When that comes, you want to be prepared to deal with it in a calculated, considered, and thoughtful way. We saw in Rome the consequences of the absence of policy which could provide a guidance to the delegation there when Washington finally woke up to what it was that were happening there. That could happen again if suddenly, unexpectedly, but almost predictably, we have a very negative development of the court that has to be coped with.
John,
just 4 seconds, please, Michael, and I'll finish. The issue here is that we need a policy which can produce produce decisions on these emerging issues that are not lower common denominator issues, that are not plagued by the fact that disagreements between different parts of the U.S. government have not been resolved. The policy process can resolve those disagreements, but it will be painful and difficult to do that. And the administration right now has decided that because of other demands on the Department of Defense and other reasons, it does not wish to go through that painful process now. Thank you.